Started? All right. Good afternoon. My name is Lane Borg. I'm the Executive Director of Metropolitan Public Defenders. What the three of us are going to be talking about today is we've loosely termed reimagining public defense. For those of you that have that have heard us speak before on this, this is a endeavor that Metropolitan Public Defenders is really committed to a road we're going down in terms of changing the way you think of public defense. Historically, it's been responsive to charges without really engaging the system in a different way. So we're going to be talking, my part in this is to give you some background as to kind of where we're at and how we got here, on how we fund public defense, and some of what, at least from my opinion, what are some of the challenges to how we would change or reform that. And then we're going to hear from the good doctor from PSU is going to talk about how we would measure that if we get to that. I mean, if we can make those changes. And then Alex is going to give you more of an idea of what a fully envisioned office would look like that would be doing that kind of work. This is aspirational. I'd like to say that this is the standard everywhere, but it's not. If it was, we wouldn't have to give this talk. But I want to start with a couple of like where we're at now and how there's some truisms that I think people accept about public defense and about our system, and that would be the first is that the Constitution requires due process. In fact, the Constitution requires due process. There's even a due process clause, conveniently. And the Constitution requires equal treatment. There's an equal protection clause. And at least for the last 50 plus years with Gideon versus Wainwright, the Constitution has required public defenders. And that's great. You know, when I've been the executive director of Metropolitan Public Defenders for 8.5 years now, been through the big recession. We had cuts. I quoted very often in those days, it was a good thing to be constitutionally mandated as compared to my brothers and sisters in legal aid that had their funding very much in peril. And it's true, but one problem is this constitutional imperative has, for us in public defense, created both a floor and a ceiling. Because, as I like to tell people, and told some people today I would be doing this, we are the colonoscopy of the public safety system. We are necessary, but not desired. And people see us as something they have to pay for, they have to do. But they don't look to this as a desirable, integral part of the system. And it is also, because we are desired, or because we're necessary but not desired, it's led to the thinking of us in terms of efficiency and adequacy. So people don't go and get the Cadillac of colonoscopies, right? You just get the one that's good enough and it's going to tell you what you need to know, and then you're good to go. But when you're starting with adequacy, then you start thinking about, okay, well, what's the standard of care? What are we going to be measured on if we do that? And I would like to say the case for the law geeks is Strickland. I would like to say that this is the standard, that, having, Gregory Peck up there and, proving to everybody that in fact his client is not guilty despite all of the societal mores at the time. But that is a lie. That is not the standard of Strickland. This is the standard of Strickland. Put in layman's terms, was the defense horrible? Literally it is, you have to show that whatever the defense attorney did was the cause of the conviction, that with pretty much, not beyond a reasonable doubt, but pretty much beyond a preponderance of evidence that whatever this attorney did that was an error is what caused the bad outcome, is what caused that. Well, that's a pretty low standard to aspire to, is were you horrible? And when you're looking at efficiencies, what we get is and the way we fund public defense in this state, and I want to say this, I'm not trying to be critical of the Office of Public Defense Services. They're enacting the legislation that we have passed. This is what we do. We get paid per case. We get paid an X number of dollars for a felony, X number of dollars for a misdemeanor, and the problem with that in this scenario is that it maximizes efficiency in the way you handle it. If you can get rid of that case faster and cheaper, you will do better under our current system, because you get the same amount of money whether you go to trial or whether the person never shows up or it's a quick plea or you spend 3 weeks in trial. We get the same amount of money. I'm the largest public defender, not physically, I'm the largest public defender's office in the state, and I get about $400 for a misdemeanor case. And as I've said many times, I can't, somebody says, well, we talk to policymakers and legislators, well, how can you do a misdemeanor for $400? I mean, it's ridiculous. And I say, I can't do a misdemeanor for $400. I can do 1,000 misdemeanors for $400. But that's again pushing us towards this efficiency model that makes you're not incentivizing the lawyers to say, do I need to stop? Do I need to do something different? And in the extreme, we get the outcomes that we saw, if you're familiar with a case in Washington State, municipal case called the Mount Vernon case, where you had 2 defense attorneys handling about 5,000 misdemeanor cases, and when they did the analysis on it, they were literally it was minutes per case that they were spending on that is the amount of time that the defense worked. And the courts, not surprisingly, just found that in and of itself did not meet the standard of Strickland. But this pay per case, the other thing that it does is that it drives. I mean, in its darker additions or darker manifestations, it drives you to say, if I can do more cases, if I can plead them out quicker. And I want to be clear, not every public defender is doing that. In fact, the way it works in my office is, frankly, most of the lawyers in my office have no idea how the business of the office works, and so they're motivated by other things and they're incentivized by other things. But it does have the effect, because if we're driving the cases down, we're driving the cost per case down, then my budget is much smaller, and I can only afford to pay them so much money. And it's this constant debate between how big is your caseload and how much are you able to pay. And to give you a scope and scale of what I'm talking about when I talk about how much money or how little money we spend on indigent defense in this state, the Contract Services Division, so what you pay for all the public defenders in the state, that's not only people in my office or offices like mine, the 501c3 public defenders, but also for consortia, private bar. We don't really have any state public employees that are trial level public defenders. But that number that we spend in a biennial basis is, I think it's just under $200 million. And sounds, hey, that's not bad. But I have asked people, how much road, if we were building a 2-lane road with that money, and it's from dirt, we're not like repaving, but if you could build a 2-lane road from that, and I asked a lot of people in preparation for this, how far could you build that road? Now, keep in mind, my office is up in Portland. Well, I couldn't make it to this convention center. It would build about 27 miles of road. And that's what we're paying for on a biennial basis for the entire trial level system. That has a corrosive effect on the system, even if my individual lawyers and staff members are motivated and want to do a good job, but there just is so little money in the system to do that. The other thing that is a challenge and a problem with the current system is that it shuns evaluation. And defense attorneys have to own a big part of this. We don't want to be judged. We don't want to be evaluated. We have this sort of pirate mentality. We're here to mess you up and to get our client walked out the door, and don't judge us, don't evaluate us. And I'm going to defend that for trial work, because you need that kind of mentality to say you're going to fight hard for the client and do everything you can within the law to do that. But the reality is my office is pretty damn litigious. We try a lot of cases, both in Washington County and in Multnomah County. But even in Washington County, where we try more cases than downtown, we're only about 12%, maybe 13 on a good week, okay? That means, and be generous, maybe have a few other cases that fall out in a different way. 80 to 85% of your cases are resolved by a plea. And at some level, that's a plan. The parties have come together. A defendant's going to stand in front of a judge and say, yep, this is the way I want to do it. Prosecutor's going to stand up in front of a judge and say, yes, this is what we want to do. And nobody's asking how that plan worked out. We do the pleas, we send people out on this, and we're not evaluating what the outcomes of those are in any kind of meaningful way. And I want to say I own the fact that the defense attorneys are part of that too. We have shunned that analysis, and that's something that I'll talk about in a minute. I think we need to change. So in one sense, the system is operating it's operating very well. If we had an economist that was looking at this, they would say, you've got a great system, because if the standard was the defense attorney horrible, and can you get it as cheaply as possible, we're doing very well, because we're disposing of, thousands and thousands of cases for a relatively cheap amount of money, and we're cramming them through. We have, I don't want to speak to other jurisdictions, but Multnomah County is one of the fastest dockets in the country for a metropolitan docket. We're closing out 85–90% of our cases in like 120 days. It makes civil lawyers head spins that it would be that fast. But we are favoring efficiency and cheapness over I think quality and really analyzing what it is that we're doing. But if you look at the standard of what's reversed on appeal, what's granted on PCR, very little. There's very little on that. Of course, remember on that, it gets worse on the Strickland standard in that not only is the question, were you horrible, but we're going to rely on the record of the person who's being judged to figure out whether or not they did a good job, because that's the person doing the PCRs happen years and years later, and it's very difficult to figure out what facts were available, what was going on there. So if we want to change this, what can we change? What could we do? Well, I've really postulated that there's three pillars to this system I've described. One is that we have a low standard of review, we favor efficiencies and cheapness, and we shun analysis and outcome review that way. We could add money to the system. That's one possible solution, is let's just pump a whole lot more money into the system. And that has been actually tried at some levels around the country. But if you don't, I submit, if you don't change the other analysis, then you may not get any better outcome from that. Just adding more money, as necessary as that is, may not give us any better outcomes that way. The other thing is that you could, with one case, you could change the standard review. If Strickland, instead of saying, were you horrible, said, well, the question is, was there anything that was done that wasn't excellent, and I know it's not a very legal standard that way, but that wasn't excellent, it would be a game changer, because now you're going to be, I'm going to be going before a judge and saying, if you don't let me do this, then this work is for naught. It'll be overturned. It's not going to stand. And I was given some support for that. If any of you heard the story on Think Out Loud last week, where Governor Inslee, in Washington, was announcing his moratorium on the death penalty, one of the things that he cited was that it was, he looked at death penalty cases and he said 75%. Now I'm going to quote him, I don't know this, I can't say I've independently verified those statistics, But he said in Washington, 75% of those cases are coming back on review or appeal or being overturned. He says, if I'm investing in something with a 75% failure rate, that's a bad investment. This is not the way I want to spend the people's money in trying to do that. So I think that if we change the standard of review, I'm not very hopeful that we're going to get that in the current configuration of the courts, that Strickland's going to be overturned and that the bar is going to be raised much higher. But that would be another potential solution. The other is, and what I want to spend the balance of my time on this talk talking about, is if we changed the focus, if we instead of really changing the definition of success and started focusing on outcomes, or what Alex is going to talk about in a little bit, of solution-based defense, in which we emphasize the outcome of the client as the standard of review or the standard of what our goal is. Now, other places, you may have heard this, the Bronx Defenders likes to talk about this in terms of holistic defense, providing wraparound services. Ours is what we're talking about and we're trying to institute at Metropolitan Public Defenders is a little bit different, but it starts because of how we're resourced. It starts from the idea that what we're asking for is to be evaluated on what the long-term outcomes of our clients, of the work we do for our clients. Now, I said before that 85% of the cases are pleas. The thing I have to tell you is I don't know at arraignment which 80 or 85% are going to plead. I know year after year it will be that, but there's still going to be a percentage that go to trial, that should go to trial and need to go that way. But if you take this approach where you're emphasizing the outcomes, the solutions to the client, it's easy to see that you can decouple the end result of the case from the work you do for the client now. Because if you're going to be effective on that, if we could figure out a way to incentivize that, then the work we're doing now is get on it now, figure out what the client needs and how they're going to be long-term successful, in a long-term way successful, and then the outcome of their case is the outcome of their case. It's not like we're going to say, well, gosh, we would have put you in that housing program, but we won the trial, so forget about it, you're back under the bridge. I want to get my lawyers, I want to get us thinking about how can we make this client successful so that they're not coming back as a repeat client. They're not coming back into the system, and that we can have just better outcomes. And the other thing is that the outcomes, I think there's for those of you who are defense attorneys in the room, you're probably already having the gut check. For those of you not, you need to understand that last pillar, that last concept, is very challenging to defense attorneys. It's very scary because we're feeling like, hey, we get our clients assigned to us. We've got clients that have already been so damaged by a system that we're receiving, and now we have to be responsible for their outcomes. But I don't think it has to be that. I don't think it's that the rule has to be, if I'm measuring outcomes on public defense clients, that somehow we're going to blame them for all the results. I think it doesn't have to be that way at all. It might be, and I'm going to own the fact, it might be that it is the practices of the defense counsel that has added to, that has impeded that solution. But it might also be that it's the system's problem, that there's some other problem in the system. But unless we measure outcomes, we can't even start that conversation. But I think that we've certainly discovered this in the MCJRP program in Multnomah County. That's the JRI program that has been very successful in diverting people from prison, and we are measuring the outcomes. We are owning the data on the people that we are having an effect on this. And one of the things that we're starting to do, and I knew we would do this when we got into it, was to a large extent we are cataloging what we don't have. We are seeing the needs and risks, or the risks and needs of the individuals that we're diverting from prison. And we are finding that we don't have enough COG programs. We don't have enough housing. We don't have the right kind of spectrum of alcohol and drug treatment. It is imperative for public defenders, in the view that I am advocating for, solution-based defense, that we can't stop our advocacy when we get the verdict or the result from the judge. That the advocacy has to continue in terms of saying, you did not give my client what you knew they needed at the time of sentencing. So don't revoke their probation now. for not doing drug treatment when you never offered them drug treatment. And that isn't a hypothetical. I literally have that file on my desk now from one of my lawyers. So that is the, that's what we would like to see happen in terms of really looking at results. Oh, I got away from my slides a bit. So how do we do this? If we can change the definition of success, then we change it to success requires due process. And success requires fairness. And of course, my favorite, success requires public defenders. Because in this paradigm, in this world as I envision it, we quit seeing public defense and public defenders as a necessary evil, or as I said, the colonoscopy of public safety. And instead, we see public defenders as an integral necessity of any successful public policy program. Because we have access to the clients in a way that's unique to anybody in the system. We've got confidentiality. We can work with that client from the very beginning. We don't have to wait till the end of the case. And we can start planning for what they are going to be successful with. But it's going to require a partnership that the public, the legislature, and the courts and the system also sees us differently and funds us in a different way. Don't fund us in a way that incentivizes efficiencies, cheapness, quick resolutions with blindness towards what the results ultimately would be. And with that, I'm going to turn that over to the good doctor.
Thank you, Lane. Appreciate it. So, unfortunately, my slides are a little bit drier, and speaking of colonoscopies, we're going to talk about methodology now, the great world of data. There's a few things that I want to get into before we start talking about issues related to measurements and outcomes for public defenders that you may or may not have thought about before, and what you can do with those, and how you think about your role, or think about the role of public defenders when we contextualize it in the grand scheme of the criminal justice system. So before I get into that stuff, I want to speak briefly to evidence-based practices, the idea of evidence-based practices, what it means, essentially. Most people have this idea that evidence-based practice simply means data-driven. And speaking of low bars and expectations of what you can get out of studies and research, that's the lowest. You have data, therefore it kind of tells you one thing, and we're just going to follow that. You should hold evidence-based practices, this idea, to a much higher standard in the sense that, has it been replicated? Have you been able to find the same things in different jurisdictions? Are you using the same levels of measurement? Are you using the same types of measurement? And if so, how does it transfer to your jurisdiction and the things that you can collect? And while I might be thinking about, or while I might be touching on a lot of issues that you all might already know about, a lot of public defenders and their agencies don't know a lot about data and what it can do for them. So I'm part of the Indigent Defense Research Association, IDRA. It's growing in popularity. We're trying to gather as much interest as possible. All it is a forum, a way for you as public defenders, or you as agency managers or researchers to just get in touch with one another. It's literally an email listserv, and we have calls every now and then, and we talk about what's going on in your jurisdiction. Is there any way that we can help as researchers? Can we talk about methods of measurement? Talk to the Bronx defenders, et cetera. And some of the things that keep popping up again and again when we think about barriers and what public defenders run into, and then how do they get across those barriers and deal with those barriers, it often speaks to, well, what can data do for me? I have a bunch of data, or I haven't started collecting data yet. What do I need to collect? Or what do I do with what I have? And I want to speak real quick to the importance of data, because it's lost to most of those who are not part of IDRA. Using data in a meaningful fashion can actually help you and your agency figure out the definition of a particular problem. I've talked to a lot of, whether it be attorneys or directors or past public defenders, And first of all, they say, you're not a public defender, you don't know what you're talking about, you don't know my job. But once we get past that, not all of them do that, but once we get past that, I let them know that, you know what, I realize that you can identify a problem by seeing it. I know that problem when I see it, and we can just get past it. The other thing that data can do for you is define that problem. It can actually give it parameters. It can give you evidence to go to either the legislature or to the director or just reevaluating your process. It can give you that evidence and support and direction that you may have lacked in your subjective analysis, so to speak. The second thing it can do is highlight points of comparison. Not a lot of people like to compare across cases. Cases are very different. You can't compare across different attorneys. It's just not possible. Well, I'm here to tell you that if you can measure it properly, it is possible. There are certain limitations, of course. You have to keep those limitations in mind. It's no different from any other data that we find in the criminal justice system, yet we still use it, right? It is still meaningful, okay? It highlights points of comparison. Third, it exposes strengths and weaknesses, and a sub-portion of that, not only does it expose certain strengths and weaknesses you might not have known about, but it defines them. It defines their importance. How important are those strengths and weaknesses to what you're doing? And how do you define what you're doing? And it gets you to start reevaluating this idea of success, this idea of, are we just simply meeting the low bar and kind of hanging out and moving through the ranks, shoveling people in and out of the system? You're trying to do your due diligence, of course, but is there something else that you could be striving towards? And then lastly there, it helps identify data helps identify causal mechanisms. So if you can identify a cause, then you can identify a solution to that cause, okay? You can identify something that can actually target that specific cause to the barrier you're talking about. And it kind of boils down to, when you think about barriers and data, if you're not measuring something related to a particular problem, you identify the fact that you have a problem, I know it when I see it. But if you're not actively measuring it, then you're not all that serious about getting rid of it or overcoming it, okay, or meeting your goals. So, when you think about barriers and data, you want to make sure that you specifically define your goals, specifically define what is your concern as an agency, what is your concern as a public defender. It starts with that, and then you can start moving forward with, well, all right, do we already collect something? Do we already have something that is long-term? If not, then maybe we should establish something that is digital and helps us understand what cases are going through the system. Those are long-term ideas, long-term goals, long-term solutions, right? You also have this opportunity to do more short-term targeted data collection. That takes a concerted effort. When you have a question about caseloads and that magic number of can you identify a particular caseload that is too much, right? Or maybe you were talking about pay or whatever the case is, you first have to get that concerted effort to find that evidence. And sometimes that is the painstaking process of logging hours. For how many hours did you spend on what cases and what exactly did you do during those hours? And it is painstaking, and it needs to be a concerted effort. You can hire researchers, or you can find researchers, you can embed researchers, and that's great. Still takes a concerted effort, still takes a targeted, meaningful process to collect that data systematically to where it can be replicated again and again and again, or be defined in a way that's actually speaking to your goal or concern. Oops, jumped ahead of myself there. So, what can be measured? So the NLADA, the National Legal Aid and Defender Association, put together this RDA, or Research and Data Analysis Advisory Committee, and they came back with this idea that all public defenders across the nation should be collecting at the very baseline level some element of these three things. Process of case management and case events, what's going through the process, how is that process taking place, can you capture any types of decision points along the way? Secondly, case disposition or the sentence and/or sentence. And then who, of course, handled the case. Can we attach this to a particular person after the fact? Are we talking about just aggregate numbers? And at some point, we're going to need to start talking about individuals. This isn't playing a gotcha game. This is a trying to help you game, right? It really depends on how you define those goals and concerns. And with the NLADA, who consulted with Dr. Andy Davies out of SUNY Albany, they put together a list of potential measures and influential factors and how you might be able to operationalize or specifically measure those influential factors, right? So they list a few things here, such as workload, motion practice, and procedure, all of which seems like that's common sense to a degree, or it seems like that's so common sense, why do we need to measure it? Or on the other hand, it's so crucial that you need to measure it in a very minute and nuanced way so that you can actually come back and ask for or make the case for, here's what's going on. How's my public defender agency doing? The answer to that question lies in these measures, is what they're essentially arguing. One thing that I want to highlight out of the top portion of that, where we're talking about influential factors, is this idea of client contacts. This often gets overlooked by most public defenders, most public defender agencies. It's not really one of those key areas that they try to collect. If it is part of your typical collection process, you can actually speak to how much time are we spending with our clients? Are we only seeing them in the courtroom? Does it have to do with caseload? Does it have to do with the lack of resources? You are then able to tie that information together so long as you're collecting it. In the bottom portion of that, they suggest particular outcomes, many of which seem pretty self-explanatory. These key outcomes are commonly thought of with public defender and court records, such as pretrial detention and sentencing. But I want to highlight that other client aspect again. In particular, there are short-term and long-term potential outcomes for your client. So we were thinking about whether you lost the case or whether it got pled down or whatever the case is. If you're thinking about success in a different way, this is where it has to start. It's that client measurement. You can do it on a larger scale. It doesn't have to be a very targeted, very time-consuming method. This is something that can be logged rather easily and digitally. There are many places that are actually doing this. North Carolina set off a statewide attempt to try to do something similar. The Bronx Defenders, of course. There are a number of them throughout the nation that are starting to look towards this more, aka holistic offense, or defense, rather. So we need to think about those long-term solutions, especially the recidivism in 3 years and employment after the case, for instance, as long-term sustainable solutions to potential problems or potential issues with the current status of how we use public defenders and what we expect from public defenders. So with that, I want to transition really quick in thinking about long-term goals. I want to transition and kind of think back to those of you who are in the risk assessment discussion. This is probably going to be a little bit of a review, just because we're using what we know from community corrections to help inform what we can do for public defenders. So in community corrections and treatment and rehabilitation of offenders, it's one of my primary areas. We recognize through lots of data, lots of studies, lots of qualitative studies as well as quantitative studies, that get at these major domains of what to target in an individual to help reduce someone's likelihood to reoffend, right? So these 8 primary domains, which you will find in most risk needs assessments, varying from assessment to assessment, can be this kind of blueprint to give you an idea of what you can target potentially at the front end of the system. The crazy thing about these domains is that we don't collect this information, typically, until after the conviction well after, well, maybe they've started probation, sometimes it depends on the department, or well after they've been through prison. And now they're coming back out on supervision, and we're going to try to target them, those needs now. Why not think about targeting these needs at the front end of the system before the social and fiscal costs arise? So, thinking about this, there are certain areas that when thinking about the public defender and their unique situation in the system, they can actually help to maybe target a few of these. We're thinking about maybe housing. We're thinking about employment, substance abuse. Is there a mental illness that needs to be addressed immediately? That has that potential. Alex will talk a little bit about this finance area. There are a number of things that if you think about the public defender in a different light, and define success in a different way, that you might be able to affect recidivism, reduce their likelihood to reoffend longer down the road. So this goes with this idea of emphasizing the client over the case outcomes. And I haven't been watching my time. I think I'm all right. Emphasizing the client over the case specifics and case outcomes to try to address those long-term issues. And this isn't just from community corrections. Recent research, my own included, as well as a few of my colleagues out of Indiana and Kentucky, have been looking into what is to be gained from focusing on the client. What is to be gained from client satisfaction, for instance? I remember the first study that I was involved in, we tried to talk to clients of public defenders, and they said, yeah, they're going to hate us. Why are you going to talk to them? They're not going to give you any interesting information. And we said, well, we still like to talk to them regardless of what you may think about it. And in all actuality, the majority of the clients, the overwhelming majority of the clients that we spoke to out of Hamilton County, Cincinnati, Ohio at the time, and this was replicated in Indiana and Kentucky as well, was that they were satisfied. They were very satisfied with their representation. They were not only that, but they recognized, verbally, explicitly saying this, they recognized that the public defender is strained. They know that there is a lack of resources. They understand that you have a huge caseload. And they realize that, and that kind of factors into how they were treated. But then you have to think about how were they treated, right? So a couple of the main things that we realized from this research, figuring out what exactly could be gained, and we realized through procedural justice, our perceptions of procedural justice, if we increase that humanistic perspective, that holistic approach to where you actually care about the individual and you're trying to connect with them on a humanistic level, they might be more willing to cooperate and comply with court decisions. They might be less likely to seek appeals or complain formally about their defense. And they might be more likely to actually accept any type of rehabilitative component tied to their court sentence that they're willing to accept because of the process was fair. Essentially, this leads to a potential in deference, voluntary deference to actually adhere to certain conditions that they might not have cared about before. If they don't think the system cares about them, there's a good chance that they don't see it as legitimate. And this has been replicated in social psychology. There's a large body of procedural justice literature that supports a lot of what we're starting to find in the courts. So, when we think about owning outcomes, this idea that Mr. Borg brought up about owning outcomes as a public defender and public defense agencies, of course you need to think about measurement. But as we think about a different potential shift of public defenders moving from focusing on a case outcome issue to a client outcome issue, what's going on short and long term for that individual, we need to focus highly on those communication and advocacy elements of the ABA. Those ABA expectations, communicate, advocate, investigate, especially those two highlighted here, are really going to help you recognize where the problems are. And you can actually start measuring from there. You can start measuring how you're communicating, how often do you contact them, these types of things. So this helps to keep in mind longer-term goals, as I mentioned before. One thing that I want to touch up on this before I close out is when thinking about how the public defenders might shift their role, we need to think about how each person in the criminal justice system relates to the system, right? There is a revolving door that we all know about, but we often don't associate it with the courts necessarily. We associate the revolving door with corrections or law enforcement or laws particularly. But key courtroom workgroup agents can actually help in slowing the revolving door if we can address those needs up front. Okay. So this idea of data-driven is picking up. So the courts have been in the doldrums, so to speak. It's been behind the times for a long time. Most of our courts research, actually the largest portion of our body of courts research started in the 70s. And that was a large number of researchers went into the courts and actually did a lot of qualitative research. There's a lot of informal processes that happen in the courts. It's hard to measure. We get it. But we can start figuring it out together how best to measure those things, how reliable those measures can be, and how valid those measures can be. And then we can start using them to progress our knowledge and practice. I leave these up here to show you there's a number of outfits that have produced reports, a lot of which supporting what I've just told you. Is IDRA, IDRA and the NAPD in particular were particularly influential in a lot of this information. And with that, I will turn it over to Alex.
Thank you. Can I have the, thank you. Okay, let's wipe away how we got here. It's a mess, and I'm not sure that it helps us in figuring out how to get from here to where we want to be. And let's wipe away the question of whether we can measure positive outcomes for our clients. We can. It's a matter of putting in place the systems that will allow us to do that. But all of those agencies and people who are wanting to punish and put people in concrete cages, they find it easy to measure these. The funding is there for them. I don't mean to malign, of course. There are many great DAs and sheriffs and police agencies out there and sheriffs and departments of correction who are trying to figure out positive outcomes themselves, and especially departments of community justice throughout the nation. But the point is, the public defense has always been on the outs, as if it is not part of the solution. That is why I want to create this new idea of solution-focused defense. I came up with this name just the other day. It's obviously part of this larger idea that Lane and I have been working on for a while, and lots of folks around the nation, but this idea of solution-focused defense, that the defense is focused on trying to find a solution for the client, a better path for the client, which will also be a solution for the community, reducing recidivism, reducing costs, better, more productive citizens, whatever it is the community desires. It is more humane and better for people. It comes from this thing called solution-focused therapy. The centerpiece of solution-focused therapy is the miracle question. You ask the client, if your primary problem was gone, poof, it just disappeared. You woke up tomorrow and it was gone. How would you know? What would that look like? So let us ask that. What would it look like if we woke up tomorrow and we were truly incentivizing in public defense, expecting from public defense positive outcomes, that we were working on a better path for our clients? What would that look like? Well, first of all, I think there would be a widespread recognition that what we are doing is poverty work. There would be an automatic shift from the case to the client, obviously, but a widespread recognition that a positive result on the case is not going to equal necessarily a positive results for the client. That isn't solely the better path. Obviously, we're always going to be working for the best result for the client on the case, but that's not the end-all be-all, and it probably isn't going to do much by itself to get us to where we need to be. I was in the trauma talk this morning where the good doctor said that 80% of people in the criminal justice system, defendants in the criminal justice system, have serious past trauma. 93% for veterans, which was much of the point of the talk. But if you think about trauma, addiction, mental health, homelessness, if you go through all of these major problems that people are likely to be having in their life, those are probably more important to that person, more important in trying to figure out how to create a better path for that person than just the result on the case. Now, of course, we also need a good result on the case. Which brings us to the point that we want to be doing top-notch criminal defense. Criminal defense for poor people sounds like that's like bad criminal defense. It's less than good criminal defense somehow. What we want it to be is top-notch criminal defense plus we are trying to figure out how to address the needs of our client. So, we're trying to figure out how to solve for this client and with the client all of those causes and corollaries of poverty, whatever it is that this person needs and wants. How else would we know, poof, if we woke up in this new world? How would we know? One way is that our staff, I think, would feel themselves within a web of resources, a web of connections, so that they would be able to access legal assistance, for example, if the person is going through an eviction, ideally from within our office. If the person has housing issues, we would have a social worker who is working on housing issues. If there are mental health issues, we would have a case manager who is working on mental health issues and can case manage the person throughout the case from the very beginning and into the community past the end of the case. Whatever the problems are, we'd be able to identify those, but we would also be connected to all the resources in the community. So if the client needs an ID, for example, and we don't provide that service in-house, it is vastly preferable to know that, for example, Elise that runs the day treatment center at TPI does that work for folks, and we know exactly when those services run and how it works, and that the person is likely going to have to stand in line one day so they can actually get that service the next. And even better is to walk with our client over to the day treatment center and introduce them to Elise. You can see that rate of success skyrocketing when there's a warm handoff and actual knowledge, right? Those connections, those relationships matter. But that's also not enough. We need to really be a part of the community. A part of the community like the amazing organization, the Rosewood Initiative, folks back there, not to call them out, but they're just doing such amazing work in one of the poorest parts of Portland. And we really want to partner with them to help with whatever services we can provide, whether that's asking to reduce fines and fees, working with the DA on a program that will lift warrants and reduce other barriers. However we're able to do it, we want to help in all the neighborhoods we can, but that allows us to be out in the neighborhoods, out in the community, creating a different relationship with the clients. How else would we know? It would be part of our job to make life better for the client, make it easier going through the criminal case, stop making it worse for the client, stop being okay with the client falling through cracks at every situation. Trauma is a great example of a situation where we often just allow things to get worse. We may understand that our client has trauma, and yet still we don't tell the court, and the court ratchets up the threat of violence, because that's often how the court system works. Do this or else I will put hands on you and take you into custody and put you in jail. It's that threat of force that the court thinks of as effective most of the time, but it can often be counter-effective in trauma situations. Another example where we let people fall through the cracks all the time is there's a period of time right after a person's sentenced, when they're put on probation, where they have to do a complicated set of steps in order to sign up for a bunch of things. And we're often spread very thin, the attorneys themselves, and we can't be with them through that time. And we just see a ton of people that kind of drop off in terms of their success during that crucial time. So we've been trying to set up a program in our office, pulling in students who are with that person and showing them how to do that through the system, showing them the right way to sign up for payments, because there's a right way and a wrong way. The places where you need to go, how to sign up for these things. And if it turns out that something costs $200 and the judge thought it was free, then we can go back to court and change the order potentially. But the point is, we are trying to figure out how to make our clients successful over the long term. We are trying to help them be successful, create the path that is best for them. Okay, so stated another way, what we need to do is assess and address all of the client's needs and shift our focus from case success to client success. And I mean all of the socioeconomic needs that are out there, the immediate crisis needs that a person has, treatment needs, medical care, mental health. We want to help address all of those things, start setting up a plan for the person. And we also want to meet those legal needs as best we can, whether it's benefits, eviction, parent representation, immigration, civil legal barriers. We want to have a team of people that are surrounding the person and helping them with whatever needs they have. That starts with a checklist of potential needs and services that a person may have. So on day one, what we want to be doing is having our legal assistant figure out exactly what the person needs. And then from there, trying to figure out what's important to the client. Maybe going through the miracle question exercise with them. If you woke up tomorrow and your primary problem was gone, what would be different? What would that feel like? And try to help the client get from here to there. This also allows us, though, to start keeping some data on exactly how many clients we have who are homeless, exactly how many clients we have who are acutely mentally ill, or maybe just in need of an ID. Maybe it turns out 20% of our clients don't have an ID, and that turns out to be some really profound driver of the criminal justice system that nobody realized. It probably is to some extent. Resource mapping ends up being incredibly important, right? When we're connecting with all of those resources in the community and creating relationships, we have to be able to know them as an office, right? So any particular legal assistant or attorney ought to be able to immediately access that information and understand the relationship we have with the particular people on the ground in that organization. So we need a mechanism within our office that allows us to do that. Speaking of which, the way that we want this to work in our office is that there is a legal assistant for every 2 defense attorneys in our office. That legal assistant would be the first one on the ground, and is the first one on the ground in our office, to be identifying the person's needs. We then surround that legal assistant with whatever people we have in our office. So maybe the legal assistant pulls in an immigration attorney from our office because we have an immigration team. And now there's a criminal defense attorney and an immigration attorney. Maybe the state is trying to take the person's children away. And so we pull the parent representation attorney in to the team. Maybe this person has housing needs, and so we pull in the social worker that deals with housing issues most onto the team. And so there's this hub, the legal assistant is a hub around which a number of people are associated, but that allows us to pull in all of the different resources to this single team. This idea of solution-focused defense does a bunch of things, right? Like zealous defense better sorts the innocent from the guilty because, okay, not everybody is innocent that we represent, but a remarkable amount of people are innocent of something that they're charged with, right? So maybe they're charged with something more than they actually did. Maybe there are counts that they are innocent of. So figuring out what the person is actually guilty of, what the state can actually prove ends up being a really important function of zealous defense. If we are putting together a full mitigation plan in the sense of figuring out what needs and resources the person has and helping them meet those needs, we have a mitigation plan ready to go if that's appropriate in the case. Sometimes it is and sometimes it isn't, but we have it ready to go regardless. Social service planning and case management would reduce the use and reuse of the criminal justice system and would reduce impact on other areas of the system as well. And of course, if we can meet those other legal needs and reduce persons' barriers to success, we can reduce recidivism and make for a better path for our clients and a better result and outcome for everyone. Pre-entry services is an excellent example of kind of this shifted way of thinking. The idea here is that re-entry is really hard for a number of reasons. Re-entry being transitioning a person from an incarcerative setting out into the community. But we make it worse. Stated another way, there are some real things that we can do prior to incarceration as public defense attorneys, as a public defense office, that will make that re-entry situation significantly better, right? So it takes 10 minutes or so to put child support in abeyance. All that requires is identifying that the person is paying child support, filing the paperwork with the state. That doesn't happen the vast majority of the time across the nation because public defenders just think about it as outside of the criminal case. It seems like a different thing. But once you shift to how do we make sure this client is on a path to a better life, well, then it seems really obvious that of course we should spend that 10 minutes, because if we don't, that debt is going to keep building up all the way until the person is released, at which point in time they're going to have collections after them. It's going to be harder to get employment. It's going to be harder to get a job. They could even be charged with a felony. The whole thing can be a mess. Same thing with other kinds of debts that people have. Family safety plans, particularly for women and children, women with children. There are a whole set of things that we can be doing and will be doing ideally in the future. Same thing with our expanded immigration department. We have a whole set of programs in our office that are designed to start addressing this full array of needs. I have 30 seconds or so left, so I'm not going to go through all of them. But the point is, these are almost all externally funded programs, but they build in, when you put them all together, to this array of resources that we have in our office to meet our clients' needs. Ultimately, what we're looking for here is better client outcomes. We want to be measured on whether our clients do better. We want that expected of us. We want to be incentivized for that. We want everybody to shift their thinking so that public defense is part of that public safety spectrum, part of the the solution on a large scale. It's not going to be the solution in every case, but we have a special relationship. We have that right from day one of that criminal case. We have the confidentiality and the relationship and the confidence that we should be building in every single case. And if we are identifying what the person's needs are and starting to put together the plan so that by the end of the case, that plan is well underway, we've done some significant case management, we can be ahead of the curve even if the system, the rest of the system, stays the same. We can make it easier for probation. We can create better results for everyone if we're working together, if we are all working together toward solutions for the clients, a better path for the clients. Thank you.
I will take any questions that people have. I was going to end with, we can't do it on 27 miles worth of funding, though.
Vertical representation. So one issue here when you do the team-based approach, which actually sounds really good, is in the process you have maybe several attorneys dealing with the same client. And I know one of the goals of NAPD is to have more vertical representation. That is one attorney on a client case. So how do you do that?
I don't think that's necessarily true. I think you want one criminal defense attorney on the case. But you don't necessarily need your criminal defense attorney to be your immigration attorney, who is also the parent representation attorney, any more than you want your attorney to be the social worker who's finding housing, right? You can have different people serving different functions. What you don't want, and the reason why horizontal representation is traditionally so ineffective, is that one person handles the beginning of the case, they do some work, they build some theories, and then they hand it off to a totally different attorney who basically has to start over. And that creates really ineffective representation.
Brooke, another way to sort of frame what we've been talking about here is trying to figure out a way to take advantage of a 90 to 180 day period that the case is on hold. Because right now, for these type of solutions, that is dead time. No one is effectively using or expecting that of it. Now I'm seeing within the MCJRP program, the treatment readiness dorm, where we're trying to address people who are in jail, take advantage of that time when they're in jail to get them ready. And the early returns on that are very promising. People are being much more successful in inpatient treatment once they get out of, and even outpatient treatment once they get out of jail, because we haven't had that dead time. But it made the system think differently to enter into things like MOUs about statements. That treatment readiness dorm needs to be treatment readiness dorm and therapy, not a snitch factory. We've got to think differently about how we address this so that we don't waste time in trying to move people into solutions.
I feel like you kind of got to what I wanted to ask or say at the end in that last little bit. To me, it's not about solution-focused defense, it's about solution-focused justice. The whole system and all the players, and even if you're just saying in the court, the judge, the DA, the prosecutor, and the defense should be focused on what is the best outcome for this individual if they are guilty of the crime presented to not reoffend. So if it's only solution-focused defense, you're just kind of one leg of the stool, and you'll fix that leg and not the other ones. And together, and then you might have pooled budgets to create your 400-mile highway, not the 27.
Yeah.
Sounds great.
Yeah.
I just wanted to point out, I'm coming into this, I was a lawyer in a past life, but then was a physician. And a lot of the discussion around healthcare transformation is, I mean, it is, you are echoing it, it's the triple aim of improved outcomes, lower costs, and improve the patient experience of care. And so much of that work seems directly analogous here.
Oh, absolutely. I mean, I didn't say it today, I've said it in other talks on that. It didn't work for healthcare, it doesn't work here. You know, this paying for events model. Yeah.
I love what you're talking about, but I'm wondering how well that works with a system, a criminal justice system, particularly a
And the way we change that is, as my fellow MCJRP people have heard me say for 4 years now, is the quickest way to change that is to get the judges on board. Because if the judges start asking the question, my friend Kevin Barton knows this, judges are responsive, we are responsive, we are competitive individuals as lawyers. And if a judge tells you the most important thing I want to know before sentencing is what time did the sun come up on June 3rd, 2003, what do you think we're going to find out? And if a judge says the outcomes matter, we're going to start paying attention to that. Eventually all of us have to be focusing on that, but we have to start that process, we have to start doing that, because then people will start, it matters, and they will start finding that out.
Are you getting some judges that do that?
Oh yeah, no, I think there are judges that, certainly there are judges in the MCJRP program in Multnomah County that are now they're hungry for this information on risk need. We even tried to dial it back, and that was shut down by the judges. They want to know, and they're starting to ask questions on that.
So this judge has been on the bench for almost 10 years. And the first question I ask when there's time to have a conversation with the defendant at sentencing is, how did this happen? How did you get yourself into this position? Before I was a judge for 12 years, I did indigent defense. And rather than approach the case in a, we have to win this case way, I essentially was doing this. My approach was, let's do whatever we need to do for you so that you don't end up in this position again. And I was very focused on that kind of solution rather than just let's get an acquittal. And I communicated well, and because I returned all of my phone calls, usually within 24 hours, and because I had that approach, not one bar complaint from a client in 12 years. Not because I'm a spectacular person, but just because that was how I approached my cases.
Similar to that, as Alex and I have prepared this talk and talked around over the last year on it, I started out from a position of I'm convinced public defense is different. It's different, we have to address it as a poverty law. And I've given that up now because I was in private practice, criminal practice for 13 years. And I started thinking about it. If I went to a client at the end of the case and said, well, you paid me $10,000 and you didn't go to jail, but by the way, you can't live where you were living, you can't be in that job anymore, and you can't see your kids, that would not have been a successful representation. Private bar attorneys that are successful are already doing this. Public defenders that have done it innately are doing it, but it needs to be addressed as a system. We need to incentivize the offices to say, this is what we expect. We expect this excellence and this outcome rather than this low bar and cheap efficiencies. David.
One of the things that's been educational for me when I'm in the County was talking about treatment readiness. And I wanted to give you a minute on that because you can really see huge differences. If you talk to treatment providers on drugs, they talk about there being different stages of treatment, and there's pre-contemplative, contemplative, and so forth. Pre-contemplative is, I don't have a drug problem at all, there's nothing wrong. Contemplative is, maybe I ought to make a change, maybe, I don't know, maybe. And then, so forth until you get to the person who's really, I gotta change my life. If you're just having people go through the system and just get sentenced into treatment, and they're not even ready for it yet, that is a waste of time and a waste of resources. And doing these things pre-sentencing to kind of get them ready to get treatment makes a huge difference. So part of it is the context of defense, but part of it is the context of how treatment works. And I think that's a really big point that our system, I think, is really uneven.
There's another aspect, and we didn't get into this today too, but is that another project we've worked on is a student project. We bring a lot of students in as first years and second years, and there's a tuition reimbursement process, a loan reimbursement process. If you work at a public defender's office or at public interest for 10 years, you get a lot of tuition remission on that, loan remission. What we're finding is, even if we thought everything we told you today was bullshit, okay, we should be doing this because this is what the kids that are coming out of the excellent law schools want. This is what they want. This is social justice. And if you're not offering this, then they have other places they can go. People don't want, the people as they come in the door, they don't want to just be like, how can I be burned out? How can I grind through this and not care about what's going on? That's not where they're starting. And so we're finding that it's a competitive advantage to us in attracting better students and better lawyers by offering this approach and focusing on the larger social justice issues.
We're getting the wrap-up signal.
Sorry.
Thank you, everyone.
Thanks, guys.